Welcome to literary and jury charge practice. Let's get started with actually some literary material. And this is a continuation of the literary that's called 10 Reasons to Camp. 10 Reasons to Camp. Okay, ready? Values and value. Because it's more than an affordable getaway from a bottom line perspective. Camping puts our values in clearer focus by showing us how little we really need to be happy. Starry skies. Camp cuisine. Because camping is an excuse for feasting. Camp food can be as simple or fancy as you want to make it. You'll find quick, easy recipes at KOA.com. Camping recipes. Dog friendly. Because man's best friend deserves a getaway too. Many places accept four-legged friends. Just be sure to check ahead. The stories. Because making memories, and not just the warm, fuzzy kind, is a big part of camping. Tales of outdoor adventures gone horribly wrong can give you plenty to laugh about for years to come. All right, so that's the reasons to camp, I guess. Let's see, I thought there was, let me see, a couple words in here that might have been a little bit challenging. Affordable. Recipes, memories, adventures, horribly. Okay, let's do some jury charge practice now. This will be the end of one we started working on before. Right, ready? At the time of jury selection, the judge usually knows or figures how much time the jury trial will take. it may go on for longer periods, but he is able to figure out approximately how much time is involved. During deliberations, jurors will examine the evidence. They will have to review the exhibits in the case, rule out any evidence, and consider the arguments of the attorneys. The opening and closing arguments are very important. In the opening statement, each attorney tells what he or she intends to prove in the case. In the closing statement, each attorney explains why the evidence that was produced in trial proves his or her case. The judge makes it clear in his instructions to the jury that the opening and closing arguments are not evidence. This is told to the jury so that they do not confuse what the attorney is saying with what is actually the evidence in the case. The judge may also explain to the jury what the function of the witness is and explain the difference between admissible evidence and evidence that is not admissible. The judge may explain the meaning of the objections that were made. Judges sometimes go into long discussions about what should be considered as evidence and what should not be. Let me just go over a few words. We had admissible, admissible evidence, arguments, opening arguments, closing arguments, deliberations, deliberations, all right. Let's do some literary practice. These are tips for beginning campers. Tips for beginners. You're just starting to go camping. Ready? Don't invest in a lot of stuff until you decide you actually like camping. In the meantime, try renting tents, sleeping bags, and other basics from major outdoor retailers, or borrow them from a camping savvy friend. Better yet, invite that friend on your trip. Make a packing list so you know what to bring and what to leave behind. Outdoor Outfitter, REI, has a detailed checklist at rei.com. Large plastic bins are a handy way to separate cooking gear, food, and miscellaneous supplies. Without question, one of the most difficult tasks is putting together the tent. To avoid the aggravation, practice setting it up, including the rain fly and the tarp, in the backyard or living room first. When loading your car, put in your tent, sleeping bags, and other things last, so they'll be easily accessible when you arrive at your campsite. Bring warmer clothes than you think you might need, plus some extra blankets. Temperatures can drop dramatically after the sun goes down. All right, let's see. Temperatures. Temperatures, accessible, aggravation, retailers, outdoor retailers, savvy, camping savvy friend. We had the outdoor outfitter, REI, outdoor outfitter, REI. REI is all caps, no periods, no spaces. I've actually heard of REI, even though I'm not a camper. All right, so now let's get back to some jury charge practice. This will be a new one. This is on the Miranda Decision. Miranda writes, constitutional rights. Ready? When a person is read his constitutional rights according to the Miranda Decision, he is said to be Mirandized. A person must be Mirandized, or the state will not have a case. A person must be Mirandized or read the rights of which he must be informed according to the Miranda Court decision. If a question occurs as to whether a person has been Mirandized, then it is possible that even if a good case exists between or against the defendant, the case will be dropped. Police officers have to be trained that the reading of these rights is most important. There are many stages in a criminal matter. It is important that a defendant understand the various court appearances and what may be required of them. It is also very important that the defendant understand just what rights that he has before the law. A defendant has a right to an attorney to defend him in a criminal proceeding. The court will appoint an attorney for the defendant at no charge if the defendant does not have the money to hire an attorney. At the end of the case, the defendant may be asked to pay all or part of the court for the court-appointed attorney, depending upon his ability to pay a portion of these costs. Whenever someone is charged with a crime carrying the possibility of 6 months or more in jail, the defendant has the right to a speedy public jury trial. At the trial, you are thought to be not guilty and will not be convicted unless a jury of 12 jurors are convinced of your guilt beyond a reasonable doubt. The attorney gets to participate in a review of the people selected out of which the jury will be picked. It is important that the attorney selects people who will be fair in hearing the case. Jury selection is important. As a defendant on trial, you have the right to confront and cross-examine every witness who gives evidence against you. The witness will not be able to write a statement and have it read in court by someone else. The defendant has the right to attack that witness and show how he or she is lying. The witness must be in court to present his own testimony. All right, that will conclude our jury charge and literary practice. Thank you.